addressing only the issues that matter most. Wake up right now on KLZ 560.
And welcome back. Horace Cooper joins us now. He's with the Project 21 National Leadership Network of Black Conservatives to talk about a little bit more about this Ninth Circuit decision and whether or not it was even legal. I don't think it was. I didn't see a whole lot of legal reasoning going on in that decision. I saw a lot of politics. Horace, good morning. Welcome to the program.
Hey, thank you so much for having me on.
Yeah, last time we caught you, I think you were going in to make a speech someplace. We had a little snafu on the time, so we didn't get to get too deep into this. But let's talk about the Ninth Circuit.
Absolutely.
and what they're arguing back to the president with this stay didn't make any sense to me. It seemed to me like they just kind of ventured off into la land with that with that opinion. Your thoughts on that?
Well, there's a reason that many times people refer to that particular circuit as the Ninth Circus. It is unbelievable how many times the United States Supreme Court ends up having to overturn the Ninth Circuit. Their approach seems not to be so much grounded in what does the law say about a particular issue, but in many instances, what is the most fair way for us to exercise equity power? Our American courts are courts of law and equity. Many Americans aren't familiar or don't remember that before America was founded, we based much of our system on the old English system, or what the United Kingdom had. And they had two separate courts. One was the King's Court, which was what we call the Court of Law, and the other was the Anglican Church's Court, which was the Court of Equity. If there were issues of fairness, you went to the Equity Court. If there were issues of law, you went to the Law Court. Our system has tried to truncate a lot of the equity side so that we emphasize mostly about the law. Now, that's an overview. In the particulars of this case, what was most interesting to me was the fact that the court refused to examine the real question of whether or not it was legitimate for it to even make a decision. Our system has never been designed or contemplated as a way to get advisory opinions. It is interesting, if you sit down with your lawyer, for him to tell you what he thinks the ultimate outcome on something is going to be. But at the end of the day, if there is a real dispute and a real issue that needs to be resolved, we go to a court and we get an answer. And what happened here is that Washington State was allowed to come into court and say, we would like an answer, even though our interest in this is almost completely and totally tangential to the process. I'm going to make that practical. You are out at dinner, a nice restaurant in Denver, and you look over and you see a man and a woman getting into a very, very vigorous disagreement, suddenly arguments, and then she throws water on him. You don't get to go into court the next day and say, I think they need a divorce. The court requires the parties affected. In this case, Washington State claimed that there are people outside of America, some of them may one day become faculty members, some of them may one day become students at this university, someday they may marry people who are residents, and they'll be impacted by this decision. That actually violates the requirement that it's called standing, the requirement that an actual injured party show up and present itself. The Ninth Circuit, both the federal district court judge and the circuit, failed to address how it is that parties that aren't directly injured can identify any serious problems. The reason that's a concern, some people may not remember, but President Obama, at the direction of his Secretary of State, Hillary Clinton, directed a intervention into Libya that ultimately toppled the Libyan government. That action was an executive action. There was a written order. It wasn't verbal. There was a written order. If the language of this ruling, where standing isn't required, were allowed to continue, someone could actually have argued, they could rush into court and say, we're Berkeley. We're concerned. We hate war, and we would like to enjoin this because there is a primarily Muslim nation that is impacted by this order, and we believe anti-religious animus is an unfair part of that decision. That would be a very, very dangerous proposition that parties unimpacted, uninjured could come into court, and that the court itself could enjoin federal action as a result.
Unbelievable. And I had not heard it explained that way, so thank you for that. That makes it a lot easier to understand what they're doing. Now, agreeing with what they're doing is it's almost impossible. The fact that a party that is not one of the affected parties in a case can go into court and say, maybe someday something, it's possible that something might happen. Well, I mean, at that point, there is no boundary as to what they could argue because it's all hypothetical.
It's all hypothetical, and the point is a court order isn't hypothetical. If the court gets it wrong in a hypothetical case, we're still bound by the decisions of the court. Judicial modesty would require, and that's what our framers intended, we're only going to resolve a case where there's an actual injury. Now, let's go to some of the substance of what they decided, even though they were essentially taking this on a hypothetical basis. They decided that the First Amendment bar that government or Congress shall make no law restricting an establishment or creating an establishment of religion or restricting the free exercise thereof should be appropriately interpreted as if a candidate for office makes a statement that is construed by the court or any other parties as intemperate. That intemperate remark should be imported to completely undergird any other claims made about the action, and instead that should be the primary basis for assessing it. In other words, if the president ever used the phrase Muslim ban, any immigration restriction that his administration undertook would therefore have to be construed as a First Amendment violation, regardless of the specifics. Now, if you look at the specifics of the executive order, over 80% of all Muslim nations are completely unaffected as a result of this executive order. It's a curious Muslim ban in that it allows the overwhelming majority of Muslims to continue entering.
Yeah.
The reality is that the nations that had been identified were nations that the outgoing administration had indicated were problematic nations, and in fact, the legislation that the House of Representatives had passed but didn't pass the United States Senate also identified these 7 nations. It is a very curious Muslim ban that it actually is the result of the outgoing administration, which did not support a Muslim ban, the leader of the House of Representatives, Paul Ryan, who said he did not agree with a Muslim ban, and yet his House actually passed a measure that is very similar to this. The Ninth Circuit did a very, very radical thing by trying to say that you can take political campaign rhetoric and use it as the basis for understanding or defining an executive order rather than looking at the executive order itself. Very dangerous.
Very dangerous and unconstitutional, illegal, and yet they do it constantly. We see courts today taking up issues. You know, there are issues that are presented in a filing to a court, and we see the court arguing a completely different set of issues, never getting to the meat of what was presented to them. They instead argue and rule on what they want to rule on, and they direct the opinion to what they want to be thinking of or changing in law without ever getting to the specifics of the case at hand. And we see that. I mean, you see it in you see it in local courts, you see it in federal courts, and you see it on one issue after another. What's it going to take in this country to get a handle on what has been for years a runaway judiciary?
Well, one of the first things that we could actually consider doing is breaking up the Ninth Circuit. Congress has almost complete authority to set up the boundaries and makeup of the Ninth Circuit. It is the largest circuit in the country, and it is probably the most renegade circuit in the country. It would be helpful if you could pair off some of the states and localities that are subjected to the rulings to not have to have those. Maybe they have an expanded 10th. Maybe we create 11th. Some way of addressing this inequity. The interesting thing for me, and this renegade activity is very, very important for the American people to be following. It is very, very rare that the American people are successfully able to undo bad or renegade decisions by the Supreme Court. One of the biggest that most people are familiar with is Dred Scott. It took a civil war and 3 constitutional amendments to overturn the erroneous ruling by the Supreme Court defining the rights of citizenship based on whether or not you were of a particular racial group. It is very, very difficult, and that's why judicial modesty would expect that courts won't opine on matters that are hypothetical, and that when they do opine, they're going to be very careful to construe the outcome as being consistent with the existing legal parameters that exist. Mm-hmm. And that didn't happen in this case. Now, something very curious did happen, and that is that at least one anonymous Ninth Circuit Court judge asked for sua sponte review of this 3-panel ruling. This almost never happens, and what it says is someone on the Ninth Circuit thought that this ruling was so bizarre, so unusual, so lawless, and to use your term, unconstitutional, they asked for an en banc review, not the parties affected, but one of the judges looked at it. What I had hoped would happen is that would eventually be allowed to go forward, and here's why. It is not true that I predict that if an en banc review had occurred, that the decision would be overturned. But what would happen, what absolutely would happen, is a block of judges would have written such a stinging and biting analysis of the lawlessness that this decision represents, that when it got to the Supreme Court, it would be obvious to the justices that they wouldn't want to be embarrassed, even those who call themselves progressives, by embracing it. In fact, it would have been possible that instead of reaching any of the merits, they would have issued a one-word opinion simply saying this decision is erroneous, the order is overturned, and the case may continue in a way consistent with this finding. That possibly could have gotten a 9-0 determination. You'd still have to have a trial. You'd still have to have some of these basic questions addressed, but it would have sent a clear and unequivocal signal. The apprehension that I believe that the Justice Department has is that we're not confident that if this got to the Supreme Court before July of this year, that the present makeup of the court would be open to following just the law, and partisanship might break out.
Right. So the answer. So first of all, it was that I'm going to call it an appeal. I don't know. I mean, this request for this for this review of this case. What's the status of it today? Was it not allowed to go forward? And if so, who made that decision?
So the Justice Department said, we're not going to go forward, at least for the moment. We're not going to go forward. We're going to rewrite the executive order. Okay. Now, I'm going to offer up legal counsel, and since this is what you've paid for it, nothing, it will be worth nothing. But here is my legal advice. Okay. I would rewrite the executive order so that it just omitted, not expressly provided for, but omitted several of the issues that the media has identified as most problematic. And by the way, just because the media identifies something as problematic has nothing to do with whether or not it is legal. And what that would do is it would allow this underlying first case to continue. If you expressly overrule the existing executive order, then that case is dismissed. I believe it would be of value to the American people, to the legal system generally, for us to get this decision overturned because it is that lawless.
We're going to take a break here. We'll be back in just a moment. Horace Cooper is my guest this morning. We're talking about the recent decision by the Ninth Circuit Court of Appeals and what they took up with Washington State making a play in this, which just kind of caught all of us off guard here. But anyway, we'll talk about the path forward with the Trump administration when we return right after this.
Broadcasting live from Studio 56. Back to Wake Up on KLZ 560.
Horace Cooper is our guest. He's an adjunct fellow at the National Center for Public Policy Research and giving us a great breakdown of this recent Ninth Circuit opinion that apparently the Trump administration has decided to follow. I don't know if... It's probably the best way to go. It's not the way I probably would have done it, but hey, I'm not a lawyer either. Mark in the Black Forest. Mark, good morning. Welcome to the program.
Morning, thanks. I'm a little confused. When I first heard this, I was thinking, well, wait a minute. The vast majority of the people affected are not even American citizens, and it seems like the Ninth District is acting more like a world court instead of a U.S. court. So that's my confusion, and I wonder if you could shed some light on that.
Thank you very much, Mark. Horace?
Well, the caller identified one of the big problems, a huge one. Since the parties involved that would claim injury have no legal right to come into court, the court then doesn't get a chance to opine. This would be, let me just change my scenario a little bit. Two people are sitting in a restaurant, but they're not in Denver, they're in Paris. And you see them arguing, and it looks pretty serious. In fact, it's more than just water. There's like physical violence. You aren't allowed to come into federal court on their behalf because you don't have standing because you're not the injured party. But guess what? They can't come into federal court either because they're citizens of France, not of the United States. The caller is correct. Our system, and that's why I made this distinction between courts of law and equity, what might seem fair, what might seem good, what might seem caring, actually isn't the purpose of the legal system. It is supposed to adjudicate legitimate disputes, allowing people who are not residents and are not eligible to enter into federal court would completely overturn our system. even as Americans, if you wish to go into federal court, you still have to meet certain diversity jurisdictional requirements. And that means that if the issue is a couple $100 or so, you can't come in and bring your case to federal court. You need to go into a state court to address that particular dispute. The caller is exactly right. When I used to teach constitutional law, he would have gotten the extra 5 points bonus for the day.
Well, yeah. The problem, it seems more and more, is that people that are sitting on the bench across the country don't seem to be there for the right reason. I always thought that someone was elevated to the position of judge because they had the ability to make the distinctions that you just made. I mean, that was the difference between them and anybody else walking around with an opinion. They understood the law. They thought in terms of the law, which includes you must have standing and that the facts must be relevant to the case. They must be germane to what the issue at hand is, and that hypothetical things are not the same as real things. And yet every one of those things is lacking, it seems, in the temperament not only of these 3 or 4 rogue justices, but judges across this country bring bias and intimidation and this sense of what's fair and what's not into the courtrooms today. And I don't know why we even recognize a court system that is so flawed, and so rotten at its very core.
Well, this is what I commented about, how we have had a system where it is very difficult to pull the court back into its lane. And if we, as a society, want to help place curbs on the court's willingness to abuse its position, what we must do is take some actions, including things like breaking up circuits. Occasionally, it's going to be necessary to impeach, not because of a particular criminal act that a judge may have engaged in, but precisely for abuse purposes. We are rapidly reaching the point in America where a seat on the United States court, the campaign associated with it, the fundraising associated with it, exceeds that of the typical gubernatorial race, exceeds that of the typical Senate race, and exceeds that of the typical House race. In fact, we're probably going to see some amount over the fight over confirming Neil Gorsuch between $100 and $200 million raised.
My
and
goodness.
That's precisely because people on both sides understand what is at stake.
My goodness. Well, I want to have you back soon, Horace, to talk about Neil Gorsuch, because to this day, he remains kind of a mystery. We've had a couple of people on that say, well, he hasn't written on this and he hasn't written on that. But generally, he seems to be, pretty much a strict constitutionalist, an originalist, kind of in the Scalia vein. I don't know if that's enough to give me any comfort. We've been hoodwinked a few times on the conservative side. And when I hear things like Mike Pence never asked him about Roe and that decision, that doesn't make any sense to me. I don't know if that's just a lie or if that's something I really need to be concerned with. But, Horace, we hope to have you back real soon. Thank you so much for coming on this morning.
Enjoy being on the program. Thank you.
You bet.